proposed National Integrity Commission. The legislation was introduced to Parliament last month. Mark Dreyfus with today's National Press Club address.
Good morning.
Good afternoon, ladies and gentlemen, and welcome to the National Press Club and the Westpac Address. My name is Laura Tingle and I'm the club's president. It's been a long wait, but we now have a proposal for a Federal Integrity Commission. We now also have the beginnings of a debate about the details of that Integrity Commission proposal, which will be in the short term centred on a parliamentary inquiry. The architect of the Albanese government's model is Attorney-General Mark Dreyfus even. Sorry, Attorney-General. Please join me in welcoming him to address us today on his proposal.
Thanks very much, Laura, and good afternoon to all of you. It's a pleasure to be here at the National Press Club, and I'd like to begin by acknowledging the Ngunnawal and Ngambri people, the traditional custodians of the land on which we are gathered. I pay my respects to their elders past and present, and on behalf of the Australian Government, I recommit to the implementation of the Uluru Statement from the Heart in full. Earlier today, just before I go to my speech, I attended a memorial ceremony at Parliament House to mark the 20th anniversary of the Bali bombings. 88 Australians and 38 Indonesians were among the 202 victims who were murdered on this day in 2002. Hundreds more were wounded and live with the trauma of that day. I acknowledge the enduring grief of those whose lives were forever changed. And I also want to acknowledge the work of those who ran to the scene to help. Among them, many ordinary people, tourists and bystanders who made an extraordinary contribution. As my colleague Senator Wong put it in her address at the ceremony, acts of courage and of love. I especially want to thank the Australian Federal Police for the extraordinary work they did, helping the victims, identifying the dead, and assisting Indonesia to bring to justice those responsible for this atrocity. Those suffering horrific burns and other injuries were quickly flown to Darwin for life-saving treatment in what was Australia's largest aeromedical evacuation since the Vietnam War. The fact that so many survived is a testament to the work of our Australian Defence Force personnel and our wonderful doctors and nurses. 20 years on, it remains a day marked by not only the senseless pain that humans can inflict upon one another, but also the good we can all do when confronted with another's anguish. In September 2019, I stood at this podium as Shadow Attorney-General and delivered an address entitled "Time's Up: Why Australia Needs a National Anti-Corruption Commission." Actually, I've misread that. Time's Up: Why Australia Needs a National Integrity Commission, which is what we were calling it then. But it's the same thing. We needed one then, and we should have had an anti-corruption commission long before now. The former government promised one, but failed to even bring a bill to the Parliament. At this year's election, Australians put their faith and trust in Labor. I've been working every day since then to deliver the Anti-Corruption Commission that Australians so clearly want and deserve, doing the detailed design work, consulting widely and in good faith, and working to demonstrate that this is a government that people can trust. On the 28th of September, I introduced legislation into the Parliament to establish the first National Anti-Corruption Commission. This legislation is the single biggest reform to the Commonwealth Integrity Framework in decades. We said we would legislate a powerful, transparent and independent National Anti-Corruption Commission by the end of this year, and we are honouring that commitment to the Australian people. The legislation gives full effect to the design principles we took to the election. Principles developed with some of Australia's leading integrity advocates and endorsed by Australians when they elected the Albanese Labor government. Shamefully, the Commonwealth is the last Australian jurisdiction to establish an anti-corruption commission. But this delay has allowed us to draw on the best elements of state and territory models. We've brought to the Parliament an anti-corruption commission with independence, powers and resources equivalent to a standing royal commission. To use the parlance of Senator Lambie, it's got chops bigger than jaws. She's much more colourful than me. The Albanese government has committed substantial funding of $262 million over 4 years for the establishment and ongoing operation of the Commission. This funding will ensure the Commission has the staff and capacity to triage referrals and allegations it receives, conduct timely investigations and undertake corruption prevention and education activities. The Commission will investigate serious or systemic corrupt conduct affecting any part of the federal public sector. It will have the power to investigate ministers, parliamentarians and their staff, statutory office holders, employees of all government entities and contractors. Its jurisdiction will extend to conduct by any person who corrupts or seeks to corrupt a Commonwealth official. The Commission will have discretion to commence inquiries on its own initiative or in response to referrals from anyone. It will be able to act on referrals from the public, referrals from whistleblowers and referrals from anonymous sources. It will be an offence to take reprisals against those who refer matters to the Commission. The Commission will investigate both criminal and non-criminal corrupt conduct, including conduct that occurred before its establishment. The definition of corrupt conduct in the legislation is broad and is drawn from existing definitions at the state and territory level. It encompasses conduct by a public official that involves an abuse of office, breach of public trust, misuse of information or corruption of any other kind. Conduct that could adversely affect public administration but does not involve the corruption of a public official, such as external fraud or collusion, will continue to be dealt with by existing law enforcement and regulatory agencies. This will ensure that the Commission is not diverted from its core purpose of tackling serious or systemic corruption. The Commission will work in partnership with other integrity agencies, and the cross-referencing of matters to the appropriate agency is a key element of the legislation. The Commission will have a full suite of powers similar to a Royal Commission. It will be able to use its powers to undertake an investigation into a corruption issue if the Commissioner is of the opinion that it could involve serious or systemic corruption. Importantly, the Commission will undertake preliminary investigations using powers to compel the production of information. This will enable the Commission to determine whether an allegation could be serious or systemic and how it may be best dealt with. The Commissioner will have the discretion to hold a hearing in public if satisfied it is in the public interest and exceptional circumstances justify doing so. This is, I would note, in sharp contrast to the former government's failed model, which ruled out the possibility of public hearings for anyone outside of law enforcement agencies. We think our approach gets the balance right, and let me try to explain why. The experience of state anti-corruption commissions is that a very small proportion of all hearings are actually public, including the well-known New South Wales Independent Commission Against Corruption. There are important reasons why some hearings need to be conducted in private, including to avoid prejudicing an ongoing investigation or related criminal proceedings, to protect the privacy of witnesses, or to ensure national security information is protected from disclosure. The decision to hold hearings in public or in private will be made by the Independent Commissioner. The Commission will use hearings to question witnesses and obtain critical evidence about alleged serious or systemic corruption on the way to making findings and recommendations. There will be times when the Commission's investigations will be done in public. At other times, investigations will benefit from being done in private. Let me be clear, the National Anti-Corruption Commission is not a court. It is an investigative body. Its primary work is rooting out and exposing corruption. At the conclusion of an investigation, the Commissioner will be able to publish a detailed report. That report would set out the Commissioner's findings and recommendations supported by evidence, including evidence obtained in private hearings, providing transparency and a comprehensive public account of the Commission's investigation. The public can be assured that if there is a finding of corruption, they will know about it. And ultimately, that is what matters. I'd like to spend a bit of time on a really important part of the Commission's functions which have been overlooked so far. That is the Commission's power to educate and provide information about what corruption looks like in order to prevent it happening in the first place. The Commission will provide guidance and information to support the public sector to understand the concept of corrupt conduct and to identify and address vulnerabilities to corruption. This work will harden the Commonwealth public sector against corruption and will be informed by insights the Commission draws from its investigations and the intelligence it collects about corruption. This will be critical to strengthening the Commonwealth's broader integrity framework and will complement new requirements that the Government intends to introduce for Commonwealth entities to take measures to prevent, detect and deal with corruption. The Commission will also engage in broader public education about its role, corruption risks and avenues to report corrupt conduct. The independence of the Commission is fundamental to the public accepting its work and findings. We have secured the Commission's independence in a number of ways. The Commission will be able to conduct investigations on its own initiative or in response to referrals or allegations from any source. Agency heads will be required to report any corruption issue in their agency to the Commission if they suspect it could be serious or systemic. There will be an open, merits-based process for appointing the Commissioner, Deputy Commissioners and the Inspector. Those appointments will require approval by the Parliamentary Joint Committee, ensuring that appointees have parliamentary support. The appointees will have limited terms and security of tenure during their term comparable to a federal judge. The Commission will be overseen by a Parliamentary Joint Committee made up of members and senators from across the Parliament, not just government and opposition, as well as by an inspector who will be an independent officer of the Parliament. The committee will have broad functions, including approving recommendations for the appointment of the Commissioner, Deputy Commissioners and the Inspector, monitoring and reviewing the performance of functions by the Commissioner and the Inspector, examining trends and changes in corruption and reporting to both Houses of Parliament, reviewing the sufficiency of the Commission's budget and finances and reporting to both Houses of Parliament. The Parliamentary Joint Committee will be multi-partisan, comprising 12 members, 3 government, 2 opposition and 1 crossbench member from each House. We want the Parliamentary Committee established as soon as possible, following the passage of the legislation, to enable a Commissioner designate and other office holders to be appointed to guide the establishment of the Commission. The legislation contains strong safeguards against undue reputational damage. There will be an express ability for the Commission to make public statements at any time to avoid damage to a person's reputation. The Commission will be able to clarify the capacity in which a witness is appearing at a public hearing. Reports on investigations will include statements that a person has not engaged in corrupt conduct or is not the subject of any findings where that is appropriate to avoid damage to a person's reputation. The Commission must afford procedural fairness to individuals or agencies who are the subject of any adverse findings it proposes to include in a report by providing them a reasonable opportunity to respond. The legislation provides strong protections for whistleblowers against adverse consequences, including a penalty for retaliation against a whistleblower. Public officials making disclosures to the Commission will also be protected under the Public Interest Disclosure Act. Shortly, I will be introducing separate reforms to the Public Interest Disclosure Act to improve whistleblower protections, with the aim of having these reforms in place when the Commission commences operation. Many of those present have a strong interest in press freedom. So do I. For this reason, the legislation establishing the National Anti-Corruption Commission contains strong safeguards to protect the identities of journalist sources and to uphold the clear public interest associated with a free press. As Attorney-General, I'm acutely conscious that any newly created power brought onto our statute books must not interfere with the important work of the press in holding those in authority to account. The legislation... Thank you. Yeah, I thought this would be one audience that might appreciate those sentiments. There's even more. The legislation expressly provides that journalists and their employers will not be required to answer questions or provide information that will enable the identity of their sources to be identified. The Commission's access to search and surveillance powers will be subject to additional safeguards to protect press freedom and the identity of journalist sources. And the work does not end there. Improved protections for press freedom are needed, and the Albanese government intends to progress further legislative reform as a priority, including responding to important reports on press freedom from the Parliamentary Joint Committee on Intelligence and Security and the Senate Standing Committee on Environment and Communications, both from the last Parliament, in respect of which the former government did not see it as necessary to even respond. I do welcome the past and ongoing work of integrity experts and fellow parliamentarians in contributing to the legislative model that is now before the Parliament. But in examining how the Commission will work, we should not lose sight of why its work is needed in the first place. In recent years, there's been a significant erosion of trust between voters and politicians. Some of the reasons for that are global, most notably the rise of disinformation and the exploitation of it by public figures for political gain. But a lot of the damage was done here at home by the former government. Voters were not credited with the intelligence and respect they deserve. Promises were made and never delivered. Questions from journalists were treated like an annoyance. Basic standards of accountability were pushed aside. The new Labor government has a big job to do. We must repair the damage and restore trust in government. The National Anti-Corruption Commission is a nation-building reform that will help restore trust in government and in Australian democracy. Australians deserve a government that is prepared to be held to account, a government prepared to have wrongdoing exposed, even when there is a political price to pay. It's my hope that simply by doing its job, the National Anti-Corruption Commission will make government better. And of course, I'm keenly interested in the views of my parliamentary colleagues. Unlike the former government, our government has actually introduced a bill, and we've established a joint select committee to examine it, and we're joined by Senator Linda White, who is the chair of the committee. Helen Haynes is the deputy, and there is a membership drawn from government, opposition and the crossbench, and I look forward to the committee inquiry which commences its public hearings into the bill next week. I believe the government has got this bill right, but I'm prepared to listen to other views because I want the Parliament to enact the best possible anti-corruption commission. If I can just in closing make a few remarks about judicial impartiality and the Australian Law Reform Commission report on that subject. The National Anti-Corruption Commission is a central pillar in our broader project of restoring public trust in institutions. The government is also working on reinforcing public trust in the judicial system. The courts are fundamental to good governance and it's important that judicial officers display the highest standards of integrity. The Australian Law Reform Commission's recent report on judicial impartiality and the law on bias is a significant contribution to strengthening the rule of law in Australia. I'm pleased that the ALRC found that in general, the Australian public, rightly so, has a high level of confidence in Australian judges and courts. I welcome the ALRC's 14 recommendations aimed at further strengthening the administration of justice. I recently released the government's formal response to the ALRC report, outlining our support for the 3 recommendations that are directed to the government. The ALRC recommended the government establish a federal judicial commission, develop a more transparent process for appointing federal judicial officers on merit, and collect and report annually on statistics regarding the diversity of the federal judiciary. On the first recommendation there, the government has given in principle support to recommendation 5 of the ALRC's report to establish a federal judicial commission as a transparent and independent means to address concerns about the conduct of federal judges. A federal judicial commission would be a significant reform that complements the National Anti-Corruption Commission. The government is carefully considering the merits of a commission that can independently examine complaints about federal judicial officers and take appropriate action. Any model for a federal judicial commission must respect the independence of the courts and judiciary in accordance with the Constitution, and I plan to consult stakeholders accordingly. On recommendation 7, the appointment of a judge to a federal court is, of course, a significant decision. The government has already taken steps to restore integrity in the judicial appointment process through a more transparent, merit-based appointment process for the federal judiciary. While the ALRC has not proposed a particular appointment model, it noted that those consulted believed that the appointment process in place under the previous Labor government worked well. When we were last in government, the process for selecting judicial appointments included broad consultation and the use of advisory or selection panels. I've instructed the Attorney-General's Department to identify candidates to fill current and emerging judicial vacancies in the federal courts using a merit-based process. This process has involved extensive consultation with the legal community to identify suitable candidates, including heads of jurisdiction of the federal courts, the legal profession, and key members of the legal community. In future, I will consider additional measures to ensure integrity and transparency remains a key part of the appointments process. This may involve advertisements in addition to an independent advisory panel. And on the final recommendation, recommendation 8, which was directed to government about diversity, I can say that the government is committed to improving diversity in the federal judiciary. The bench must look more like the country that it serves. I want to ensure that appointments are drawn from the widest pool of candidates with appropriate skills and experience, thereby broadening the diversity and experience of those on the bench. The government looks forward to engaging with the federal courts in considering the reporting of judicial diversity statistics. Now spill the glass. Every new government comes to power promising to be better than the last. And voters, left repeatedly disappointed, have rightly grown cynical. But in establishing the National Anti-Corruption Commission, our aim is to create a lasting body, one that not only causes our government to be better, but all future governments to be better too. Integrity should be above partisan politics. It's my sincere hope that the legislation that I've introduced to establish a National Anti-Corruption Commission attracts support across the Parliament. The Australian people delivered a very clear message at the last election. Something is broken and they want it fixed. The Albanese government heard the message loud and clear. We will honour our commitment to legislate a national anti-corruption commission, and we will do it this year. Thank you.
Well, thanks, Mr. Dreyfus. There are some really obvious things that have arisen about the Integrity Commission since you released your proposal. But given a lot of the focus is on the relationship with the Parliament, I've got two related questions because I'm chairing and I can. The first one is about the committee which will oversight the Commission. As you say, it's going to have a broad range of people on it, but the government will ultimately have a casting vote as chair. Would your ambition and hope be that the committee would basically form unanimous or consensus agreements on any of the matters that it deals with? And in forming and designing the proposal, did you look at the question of parliamentary privilege and how that may affect the Commission's powers? Because, for example, in the Suicide Royal Commission underway at the moment, parliamentary privilege has become an issue that's frustrated the commissioners in being able to gain access to some information.
On the first question, Laura, it is absolutely my hope that this committee will operate a bit similarly to the way in which the Parliamentary Joint Committee on Intelligence and Security has historically operated, which is to, as far as possible, get to unanimity. And the reason for that is we want to have, in the national security space, support from across the Parliament for the measures that we take on national security. So too with this. It's really important that Australians see the Parliament coming together to agree on a model, which is why I'm hoping for support across the Parliament to pass this bill. But equally, in its ongoing work, I would like to think that we can achieve a level of consensus in the Parliament, not on partisan lines, but a level of consensus about the need to take measures against corruption, the need to improve integrity across our system. And so, yes, I am looking for this parliamentary committee, when it's established, to work towards consensus, work towards unanimity. I can't insist on it, and we'll have to wait and see how it operates, but I think that that's a worthwhile thing. On the second part of your question, which is about parliamentary privilege is expressly preserved in this bill, and I was a bit puzzled by the comments of the Veterans Royal Commission. I'm hoping that more work is able to be done with the Royal Commission, with the Veterans Royal Commission, because in fact the purpose served by parliamentary privilege is to provide a means for citizens to come forward to the Parliament. It's a way to ventilate problems and have attention paid to them, and ought not be in any way a bar to a subsequent Royal Commission coming along and conducting its own investigations into those matters. So I see parliamentary privilege as something that is an aid to accountability. It's an aid to transparency. It's an aid to things being examined, not the reverse.
David Crowe.
Thanks, Laura. Thanks, Mr. Dreyfus. David Crowe from the Sydney Morning Herald and the Age of Melbourne. The Administrative Appeals Tribunal has been a source of a lot of concern for many years now in terms of the political appointments made to that tribunal. And there's now an intersection with the issue of the Anti-Corruption Commission, because there's concern expressed by two Liberals today, James Patterson and Andrew Hastie, about who will authorise a warrant for the interception of a phone call, for instance, which could see, possibly low-level people at, calling them this, low-level people at the AAT signing off on those warrants. I'm interested in your view of whether that's a genuine concern or whether that's actually an unfounded concern, but also, doesn't it highlight the fact that in the last 9 years there was a trend towards a greater political appointment of members of the AAT? Can something be done about that? Will your Judicial Commission actually vet and approve appointments to the AAT as well?
That was clever, David. See, I was told you're only allowed to ask one question.
That was
and
one
you asked
question.
three. There's a composite question.
Multifaceted question.
I was amazed to see the story on the front page of the Australian today with 2 Liberal members of Parliament attacking the extraordinarily partisan and political appointments that their former government made over 9 years to the Administrative Appeals Tribunal. If ever you wanted a demonstration or a confirmation that something needs to be done about the AAT, there it was with these current members of the opposition attacking, in effect, the partisan appointments that they made with almost 90 failed Liberal candidates, former Liberal staffers, former Liberal members of Parliament that have been appointed. It also shows you how cynical the Liberal Party is, that they can only see government institutions through some partisan prism, which is what they've done there. I can very directly say that we are engaged in a process of looking at reform of the AAT. So that's put that to one side because we're here to talk about the Anti-Corruption Commission today. It shows a misunderstanding by those Liberal members of Parliament about what warrant issuing involves. It will be for the Commission, the independent Commission, to determine whether it is going to investigate something. It will be for the independent Commission to determine whether it wishes to conduct some telecommunications surveillance or execute a search warrant on private premises, because the Commission won't need a warrant to walk into any government department. The legislation provides for it to have the power to do that and ask for documents. So we're talking about search warrants of private premises or telecommunications being conducted on anyone, because that will require a warrant. All that the people who are charged, which might be judges and might be AAT members, all that they do in that function is to review for lawfulness. It's a very straightforward function. It's an important check and balance in our system. That's why we do provide for warrants for telecommunications surveillance. That's why we do provide for warrants for listening devices, and we do provide for warrants for search warrants. But it's an entire misunderstanding of what role is played by AAT members in that process.
The next question is from Rosie Lewis.
Mr Dreyfus, Rosie Lewis from The Australian. Just following up on Crowe's question then, if all they do is review for lawfulness, does that mean that they're just going to automatically approve a Commissioner's request for a warrant, or do they actually have a job in reviewing the request for a warrant?
Everyone who issues warrants has a job to do. One of my tasks as Attorney-General is to issue the warrants to ASIO, which for many years has been a role of the Attorney-General. And I can assure you that I take that role extremely seriously. I'm assisted in the task by skilled officers of the Attorney-General's Department who do a preliminary review for lawfulness, but I consider wider concerns as well.
So I wanted to ask then, how then can you guarantee that any of the AAT members nominated would not have been political appointments?
Well, clearly I can't at the moment, and your story on the front page of The Australian makes that clear. And it's not just me saying it, it's Mr Hastie and Senator Patterson saying it loud and clear that we've had an extraordinary politicisation of the AAT, which is quite wrong. It's severely damaged the reputation of the institution, which is something that I regret. And we are embarked now on considering what we can do about it.
Phil Curry.
Thanks, Laura. Hi, Mr Dreyfus. Phil Curry from the AFR. Just back on the Anti-Corruption Commission and just the language that was used in opposition when you were building support for it. And I go back to December last year. I think the Sydney Morning Herald had an analysis on a government's grant program which showed it was skewed towards coalition seats, and the then opposition leader Anthony Albanese said at the time, this is why we need a commission and we need it now. And he said, I put the Prime Minister on notice that a National Anti-Corruption Commission will be able to look at the sports rorts program and these rorted programs of taxpayers' funds. And I just want to ask you again, these are comments that the government, your government, has not been prepared to repeat since you've been elected as to what the Commission should look at. Does the public need to temper its expectations in terms of the political behaviour that this Commission will examine? In other words, sports rorts as it occurred Is that really the sort of thing this is going to really look at, or is it going to be much more serious and systemic behaviour than that?
I'd invite any member of the public or any journalist here who is interested in the scope of this Royal Commission to look at how broad the definition of corruption is, to look at how broad the powers are of this commission, which I'm hoping will be established by the end of this year, and consider that, as we said it would, it will have the power to look at any corruption anywhere in the Australian public service. What I'm not going to do is say that one particular instance or another of conduct, or one particular program or another, or the rorting of one program or another must be investigated by this commission, because to do so would be to fall into the error made by the former government, which was it reserved to itself in its draft legislation that it never brought to the Parliament, it reserved to itself the right to tell the Commission what it was going to investigate. This, I stress, will be an independent commission. It's possibly its most important feature, that it is independent of government. The government will not be directing it on what it can investigate. Any member of the Australian community will be free to bring forward any allegation they wish. And one of the big jobs that this commission's going to have is sifting through the material that is put before it. And that's been the experience of all of the state and territory commissions. The silver lining in the cloud of the Commonwealth being last is that we are actually able to learn from the experience of the state and territory commissions. And I know from that experience, because I've talked to very many of the past and present anti-corruption commissioners around the states and territories, one of their big functions is sifting. They have to, but it's their job to sift, not the job of government.
Katina Curtis.
Thanks. Katina Curtis from the West Australian.
Laura wants me to do some housekeeping, so I'm going to do that.
Get him elected.
I'm very obedient. Yes.
It was good to hear you talk about press freedom there. I was wondering if you could explain the interaction of the search and wiretap powers and the protections for journalists. I know there is the public interest test on warrants if they're for searching journalists or newsrooms, but what about if they're on the other end and they're capturing someone who is perhaps a journalist source and their interactions with journalists, and those warrants, the ones that would be perhaps signed off or checked for lawfulness by AAT members, can you give any guarantees that those AAT members would have legal qualifications?
It's a great question, and I can say, as I did in my speech, that we are looking at these two reports, the one from the Parliamentary Joint Committee on Intelligence and Security and the one from the Senate Committee chaired by Senator Hanson-Young, both of which reported during the course of the last term. Both of them looked at what measures might be put in place to provide more checks and balances to make sure that there is a better consideration in the exercise of these powers of the role, the really important role that is played by the press in the functioning of our democracy. What gave rise to both of those inquiries, of course, was the, I can say this here, a shocking raid on the home of an Australian journalist, something that is virtually unprecedented in the long history of Australian journalism. I won't say that there's never been a search of the premises of a journalist or interrogation of a journalist, but it's mercifully very, very rare. And that was followed by the execution of another search warrant at the headquarters of the Australian Broadcasting Commission in Ultimo. Different matters, to be sure, pursuing different investigations, but they happened in quite close to each other, and I think that really got a lot of people in Australia concerned. Both of those inquiries made serious recommendations about increasing the level of scrutiny of the use of compulsive powers. The former government said that it accepted the recommendations, so there was not only a unanimous report by the PJCIS, but the former government accepted its recommendations and then didn't do anything. We're going to do something.
And AAT members with legal qualifications or no legal?
I think that's one of the areas that has to be looked at, as is reported in Rosie Lewis's story this morning on the front page of The Australian. I'm on record as promoting the idea that you need senior people looking at particular kinds of warrants, and that's an issue particularly to make sure that what I would hope to be a very small number of compulsory powers ever used connected to a journalist, you can't rule it out. There will be investigations where this comes up, but in those very small number of cases, there's every reason why you might like to increase the level of qualification of the person who's conducting the scrutiny.
Ron Meisen.
Thank you, Attorney. Just on a slightly different topic of integrity and transparency, in opposition, you personally appeared in a matter against George Brandis to have his ministerial diary released. You said that voters should be able to know who their elected representatives are meeting. Justice Jago, I believe, appeared in that matter. You've just pointed to the High Court. She said she considers that there is a significant public interest in knowing the outline of the diary activities of elected representatives. Down the road, the ACT government releases ministerial diaries as a matter of course on a regular basis. Should that happen here at the Commonwealth level, or should at least those diaries be made available for free under the Freedom of Information Act? And just on FOI, you were deeply critical of the former government's implementation of FOI laws. You accused them of breaching them on a regular basis. What concrete steps have you taken since getting in government to ensure that public servants or ministerial officers are following the FOI Act to the letter?
It's a long project, Ron, making sure that everyone in the public service understands their obligations under the Freedom of Information Act. We had a major set of reforms sponsored by Senator John Faulkner when he was Special Minister of State in 2010, and what I've observed in the intervening period is that at some point, whether or not you're going to have the freedom of information that the name of the legislation suggests will depend on the amount of resourcing that governments put into the freedom of information function. That, for example, might mean that you wouldn't want the same person, as was the case for many years under the former government, occupying the three positions of Privacy Commissioner, Information Commissioner and Freedom of Information Commissioner. Shortly before the election we moved to two people holding the three positions, but that's something I'm looking at. But the other thing you need to do is get a different culture across the public service, and that comes from the top. We are a government that is committed to accountability. We're a government that's committed to see freedom of information working properly, but it's a long project. I don't think I'm going to turn it around in 1 week or even 1 month. It's something I'm going to continue to talk about, something I'm going to continue to work with colleagues and across the public service on making sure that there is as much transparency as possible about our government information.
Just on diaries.
And ministerial diaries. When I was arguing the case for Senator Brandis's diary to be released under the Freedom of Information Act, I pushed back extremely hard against the suggestion that this was an unreasonable diversion of government resources to the question of even vetting the Attorney-General's diary. No one has yet, this is not an invitation to anyone in this room, but no one has yet applied for my diary under the Freedom of Information Act, but I'm expecting someone will. If not before now, they will certainly now. And my view is, subject to appropriate deletions for national security matters, if they appear in my diary, that my diary should be available under the Freedom of Information Act. I would not in any sense suggest a different rule for me than the rule that I sought to apply to Senator Brandis, which was upheld by the full federal court.
Thank you.
Quentin Dempster.
Attorney-General, thanks very much for your protection and acknowledgement of freedom of the press in our liberal democracy. I realise you and the Prime Minister want your NACC bill to secure, hopefully, unanimous support in the Reps and the Senate. But how far are you prepared to compromise with the Liberal Party? your shadow, Julian Leeser, is proposing that a separate judge have the final say on exceptional circumstances for National Anti-Corruption Commission public hearings. Is that acceptable? How can you be so sure the exceptional circumstances clause won't be litigated all the way up to the High Court and back if the vested stakes are high enough?
You're following David Crowe's example of two questions. But on the first one, I've been a bit puzzled by some of the statements that the Shadow Attorney-General, Mr Leeser, has made since his leader, Mr Dutton, stood up on the day that the bill was introduced to the Parliament and said that he believed that the government had got the balance right. Now, we've consulted with the opposition, just as I have consulted with every member of the crossbench in both the House and the Senate, and I am looking forward to the opposition supporting this bill, which is why I'd say again I'm a bit puzzled about some of the comments that Mr Leeser has chosen to make since the bill was introduced. It's not clear to me that he is speaking with the authority of the Leader of the Opposition, and I'm not entirely sure why he's made a number of those comments. On the particular point that he's making about the need for a Superior Court judge to make a decision on whether or not a public hearing should be held by the Commission, that would seem to me to be a gross interference with the independent conduct of the Commission by the Commissioner. It would necessarily bog down the Commission in needless litigation. It would involve possibly quite an extensive hearing before the Superior Court judge, at which a whole lot of factors about the investigation would have to be revealed to the judge, possibly in a confidential way, possibly with all sorts of suppression orders. It barely bears thinking about how complicated it would be, and I don't think we'd gain much from it. The experience of state and territory commissions has been that not many hearings are conducted in public. And I know that there's a desire on the part of probably many people in this room for as much of the work of the Anti-Corruption Commission to be in public, but it simply can't be. It's, as I said in my address, it's not a court. It's got to look at most of the work it does in private, simply to protect reputations, to guard against prejudicing criminal proceedings, a whole range of things that are the reasons why you would want it in private. On your last question, I'm not thinking that providing for exceptional circumstances, albeit that it provides guidance to the Commissioner, is going to create some opportunity for litigation. It will remain an independent discretion to be exercised by the Commissioner as to whether or not a hearing in public is to be held. And the one commission that's published extensive statistics on this, which is the New South Wales ICAC, its experience suggests that it holds about 5% of its hearings in public.
If the stakes are high enough, though, for vested interests, their reputation and future, why persist with exceptional circumstances as a litigated clause?
It won't be. Well, I don't think that it gives rise to litigation. It's an open discretion to be exercised by the Commissioner. I'm trying not to give legal advice, and or give you a legal ruling on it, because it's not my job. But we've seen from the state and territory commissions repeated examples of people who are the subject of investigation running off to the Supreme Court of that state or territory to try and stop commissions from proceeding with investigations, or in the case of a notorious current and very long-running investigation in Victoria, trying to prevent the Commission from reporting. We've done our best in this bill to reduce, I won't say eliminate, but to reduce opportunities for that kind of interfering litigation.
Andrew Probyn.
Mr Dreyfus, when you were in opposition, unfairly or fairly, you gained the reputation as the dobber-in-chief. You referred quite a few ministers to the AFP, indeed predecessors of yours as Attorney-General, both George Brandis and Christian Porter. So when it comes to the National Anti-Corruption Commission, or NAC, when will referrals be made? And conversely, what punishment would there be for public disclosure of false allegations, given that the reputational damage is evident, to coin a phrase, that perhaps reputations would be knackered?
Thank you very much, Andrew. I'm not going to give a quote on what things should be referred or what shouldn't. It's going to be a matter for any member of the Australian community to put before...
The question wasn't about referrals, it was about when would they become public.
There are a range of safeguards in this bill that are designed to protect against unfair, undue reputational damage. And that includes keeping investigations secret. That's going to be a matter for the Commission. Making statements in hearings about the status of a particular witness, whether they're the object of an allegation or are merely appearing as a witness. Making statements in reports that, as far as possible, clear someone who has become involved in some way in a Commission's investigation. All of those, we hope, are improvements on all of the states and territory arrangements. We hope that they will go some distance to guarding against undue reputational damage.
Dom Giannini.
Dominic Giannini from the Australian Associated Press. Thank you, Mr Dreyfus. The ACT Supreme Court in May ruled that the legality of any bugging operation in East Timor was irrelevant to the charges against Bernard Cleary. So this means that we could conceivably still have a Cleary Witness K whistleblower case regardless of potentially illegal or corrupt actions by Commonwealth officials. Will the whistleblower reforms offer protections in cases such as these?
I'm not to be taken as commenting on Mr Cleary's case. I've said all I wish to say about Mr Cleary when I ended his prosecution using a very little used power. So I won't say any more about Mr Cleary, but obviously we've got reforms ahead of us to the whistleblower protection scheme of the Commonwealth. I brought the whistleblower protection scheme that is now in place, the Public Interest Disclosure Act, to the Parliament in 2013. I was conscious that I may not have got it quite right and provided for a statutory review of that Act, which was to take place unusually within 2 years of the Act coming into force. That review did take place. A very eminent Australian public servant, Philip Moss, conducted the review. He handed the report to the government at the end of 2016, and I say this a lot about the former government, nothing happened. And I've now picked up that report. I've said publicly, and I said in this address today, we are going to bring reforms to the Public Interest Disclosure Act to the Parliament next year. I'm hopeful that they will pass before the Anti-Corruption Commission is set up, but people should understand these are separate processes. The Anti-Corruption Commission has within it, in its bill, protections for people who come forward to the Anti-Corruption Commission. The Public Interest Disclosure Act is a much wider scheme that doesn't just deal with allegations of corruption, it deals with any allegation of misconduct, a breach of a code of conduct. Any maladministration in the Commonwealth can potentially be the subject of whistleblowing, brought forward to your superior, and then you're permitted, that's the way the scheme works, to go public with your allegation if nothing happens. Now, there are some deficiencies identified by Philip Moss. I'm very hopeful that we can pick up those deficiencies, act on his recommendations and bring those reforms to the Parliament in the first part of next year.
Sarah Basford-Canales.
Thank you, Mr Dreyfus. Sarah Basford-Canales from the Canberra Times. While the Coalition was in government, the funding of the Australian Human Rights Commission was slashed. Now your government has adopted all the recommendations for the Respect at Work report. To what extent will you restore the funding properly so it can do the mountain of work you've given it? And cheekily, just to add to that, the Commission is also at risk of losing its A-grade status due to a number of questionable appointments, including that of Lorraine Finlay, who you've previously described as another Liberal mate. Will you keep her in the will you keep her in the role for the full 5-year term?
The very first bill that I brought to the Australian Parliament as Attorney-General was a bill that I think will go the distance to restore or remove the threat to the A-grade status of the Australian Human Rights Commission, which the United, just for those of you that have not followed the minutiae of this, the United Nations last year threatened to remove the A-grade status of our national human rights institution, which is the Human Rights Commission, because of a lack of merit-based appointments processes. So the bill that I brought to the Parliament was one which sets up a merit-based appointments process for commissioners of the Human Rights Commission and confirms the term limits as a maximum of 7 years for those commissioners. I've got absolutely no intention of in any way altering the term of Lorraine Finlay, who is the Human Rights Commissioner. And it's a matter of some pride that that's the first bill I brought to the Parliament, because I think merit-based appointment processes are really important. I thought it was a shocking thing that Australia, which is our country that prides itself on human rights standards, and although there's always more we can do, but the thought that our national human rights institution could be downgraded to B status, I felt was something we needed to do something about straight away.
And just on the funding for...
and on the funding, I've brought legislation to the Parliament to fully implement the Respected Work report by the Sex Discrimination Commissioner, another piece of unfinished business from the former government, who said that they accepted all of the recommendations made by Kate Jenkins, but then proceeded to bring legislation to the Parliament which didn't implement all of those recommendations. I've brought a bill to the Parliament in the last sitting week which implements the remaining recommendations, with the exception of one that my colleague Mr Burke is going to deal with. And as part of that process of implementing the Respected Work recommendations, we are looking at the funding of the Human Rights Commission. It's in hand.
Okay, thank you.
Ben Westcott.
Thank you for your speech, Attorney-General. Ben Westcott from Bloomberg. I too have a multifaceted question.
Laura's the policeman, so I won't say any more.
But on the, you've got a very busy legislative agenda coming up for the rest of the year. Not only have you said you want to pass your NAC by the end of the year, but also you've said you'll want to get through privacy law changes by the end of the year in the wake of the Optus hack. Do you still think it's possible for you to do both of those by the end of the year? And in relation to privacy laws, do you think Australia at the moment currently strikes the right balance between protecting our citizens' privacy and data collection to assist our intelligence services?
Thanks, Ben, for the question. We have got a busy legislative agenda. There's a lot to get done. It's partly a product of inactivity from the former government, and there's no better example of inactivity than in this Privacy Act area. The former government commenced a review of the Privacy Act, and that's all they did. The review started, work was done by excellent officers in the Attorney-General's Department, and I should acknowledge those who are here today, the team that worked, or some of the large team that worked on the Anti-Corruption Commission bill are here, and I'd thank them for their work. But the department started on the work, but there was no indication of when this Privacy Act review was to be completed. One of the things that I've done on coming to government is to make sure that that will be brought to a conclusion. It will be finished by the end of this year. That's the review as a whole, because we have a very outdated piece of legislation in the Privacy Act. But no one foresaw the shocking privacy breach involved in the data breach from Optus, something that's affected millions of Australians in a dreadful way. And I've said that we're now looking at bringing forward from that Privacy Act review process some urgent reforms that we can make quickly to the Privacy Act, which won't be the whole piece. It won't be the full set of reforms that we want to make, but there's some things that I think we can do urgently that pick up possibly and I can't fully commit because we haven't completed our deliberations on this, but I can foreshadow that one of those amendments to the Privacy Act might be the increasing of penalties. That's something that the Privacy Commissioner herself has called for. Another might be better arrangements, because this is something that the group of ministers who immediately sprang into action when the Optus breach was notified to us, the better sharing of information with financial institutions, so that the banks, and I was just talking to the executive from Westpac who's here, there are a number of them, but in order to ensure that there wasn't more damage done as a result of this Optus data breach, because, as has been now said by many people, 100 points of identification for millions of Australians was bound up in this breach. That gives rise to possibilities of identity theft, but it also gives rise to the possibilities of a range of financial fraud. One of the ways to guard against that is the sharing of information with the financial institutions, with the major banks. And we found that the means to do that was quite cumbersome. It required regulations to be made under the Telecommunications Act by the Minister for Communications, and we would like to think that it's possible to devise a way to get that done quicker, because I'm sorry to say I fear that this will not be the last data breach in Australia's history. We need to have better information sharing when the data breaches happen. Before that, we need to have higher penalties to provide a better incentive to make sure it doesn't happen in the first place. And there's a third thing that we might look at, which is the question, and I've talked about this already, why is it that companies feel that they need to have and keep so much information in the first place? Because if they didn't keep so much information for so long, the consequences of a data breach wouldn't be so serious.
And just in terms of the balance between intelligence agencies and personal data protections for Australians, do you think that balance is currently correct?
I think it's something that we need to continually look at, and that's why the Rudd government created the Independent National Security Legislation Monitor, modelled on a similar agency in the United Kingdom. The Abbott government tried to abolish the Independent National Security Legislation Monitor, but happily did not receive support in the Senate for doing so. And the 4 independent national security legislation monitors have shown the worth of creating that agency, because their job, Grant Donaldson, the current Insulum, is looking at a range of security laws. We're expecting a report from him on the high-risk terrorist offenders legislation. The reason why we have this monitor is so that there can be a process of continuing review to make sure, to answer your question, that we've got the balance right. I don't accept that the really extreme powers that we have created over the last 20 years to deal with terrorism are set and forget. I think we need to accept that they are extreme powers. There's a reason for bringing them in, but we need to keep under review whether we still need them, and we need to keep under review whether we've got the safeguards, the checks and balances that surround those powers exactly right.
Thank you.
Josh Butler.
Hello, Josh Butler from The Guardian. I wanted to ask you about the voice to Parliament. Will there be public funding given to the respective sides of the debate? And related, does the government have concerns about an influx of private money into the respective campaigns, particularly or potentially from overseas political interest groups? What could the government do to ensure that voters get transparency about who is bankrolling the respective sides of the campaign?
It's a great question. We are looking at all of the arrangements about how this referendum on the voice is to be conducted. We've committed to accepting the generous offer made in the Uluru Statement from the Heart. I hope everyone in this room, indeed I hope everyone in Australia, has read the Uluru Statement from the Heart. It's a wonderful, wonderful national opportunity to recognise our Indigenous Australians in our Constitution. And I'm looking forward to the referendum happening. But before that, we've got to pay attention to the machinery that surrounds the conduct of a referendum. We haven't had a referendum in Australia since 1999. We haven't had a successful one since 1977, ancient history almost. If you're under 40, you haven't voted in a referendum. And we need to look really hard, and we are looking really hard, and there's deliberations now within government as to what the arrangement should be. One of those questions is, goes to your question, Josh, which is achieving transparency in donations, possibly to a greater level than we presently have in the electoral process. Another question, a machinery question, is how to make the very antiquated referendum machinery provisions look more like the electoral process that we have in Australia, which is what Australians are familiar with. So that's ahead, but you'll see more in coming months about what the arrangements we're proposing are.
Do you have concerns about overseas groups, though?
Sorry?
Overseas funding of this particular referendum, is that a concern of yours that you...
It is a concern. I can't think of a reason why there should be overseas funding permitted for campaigning in this referendum.
Thank you.
Andrew Tillett.
Thanks, Laura. Andrew Tillett, from Vice President here at the Press Club and from the AFR. You spoke about press freedom, you spoke about whistleblower reform. We've got Julian Assange's lawyer, Jennifer Robertson, here at the Press Club next week. Do you think it's in the public interest that prosecution of Julian Assange continue? And related to whistleblowers, you intervened in the case of Bernard Cleary. Will you intervene in the case of Richard Boyle and David McBride?
We're into double-barrel questions today.
Yes.
Mr. Assange's case has gone on long enough. The Prime Minister has said this. The Foreign Minister has said this. I've said this. I'll say it again. It's gone on long enough. But we're not going to conduct our representations to the Government of the United States in public. And I'll say no more about that. On Richard Boyle, his case is currently before a court in Adelaide. Mr. Boyle is now conducting a preliminary hearing ahead of his criminal trial on whether or not the provisions of the Public Interest Disclosure Act protect him. And it would be entirely inappropriate for me to comment further about that case, which is currently this week being conducted.
I've been indulging everybody today, but we've got 4 minutes left and 2 questions, so let's keep it succinct, please.
Thank you. Tim Shaw, Attorney, Director of the National Press Club. Thanks for your address today. You made this point that guidance and information to support the public sector to understand the concept of corrupt conduct. Do you want to see that extended to senior advisors in ministers' offices within the Albanese government? And would you expect those senior advisors working with public servants in those various departments to go, tell the minister it's a rort? And if it's a rort, is that policy proposal potential corruption?
Let's be clear. The National Anti-Corruption Commission is going to cover ministerial staff. For many years there's been a discussion about what is the precise role of ministerial staff. They are treated differently by legislation. They're treated differently from the members of the Australian Public Service, but we are not going to be drawing any such distinctions for the National Anti-Corruption Commission. It will apply alike to permanent public servants, casual public servants, labour hire, contractors and senior advisors, all ministerial staff from the executive assistant through to the most senior of the ministerial advisors. They are all covered. And I'm hoping that the education function of the Commission, about which I spoke in my address, will be in part able to be directed to ministerial staff who I've thought for a long time sometimes miss out on the standards training and the ethics training and a range of other training devices that are standard fare in the Australian public service. I know that we in Labor put a lot of effort into training our staff, but possibly we could do more. And one part of training our staff is now going to be able to be performed by this Anti-Corruption Commission, which is going to have an education role. I mentioned it in my address because I actually think it's really important. And it's variable between the state and territory commissions. Some of them are better at it than others, but those that do it well have got a very clear outreach function to government departments and everyone in the public sector, and it includes publishing things and conducting courses.
Thank you.
Unfortunately, we're going to have to end it there, but could you please join me